Did he view any kind of traffic infraction? I could literally call and say, hey man, the state's driving nuts. Go get him.
This woman was pulled over by police for what they claimed was a traffic infraction. But she hadn't done anything wrong.
Hold up, she gets pulled over accused of DUI, but the real reason behind this stop? Yeah, it's going to blow your mind. Let's break down how shaky some of these traffic stops can get.
They accused her of being under the influence and arrested her. But when you find out the real reason the cops stopped her, you're going to be shocked.
Wait a second, have we done PC on that? Have we done PC already on that?
Not in this court. I don't know if probable cause was already found. I forgot to ask.
I don't see that it has on my end.
Okay. All right.
Just Your Honor, no.
Ms. Dunson,
Good morning, how are you?
you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer was dispatched in reference to a wrong-way driver and initiated a traffic stop on a vehicle described by the 911 caller. The law enforcement officer made contact with the defendant and the defendant handed the law enforcement officer an unopened alcoholic beverage. The law enforcement officer noticed the strong odor of an alcoholic beverage coming from the vehicle, and the defendant appeared unstable and fell against her car. The defendant stated she spilled a whole can of beer on herself earlier. The defendant's vehicle appeared to have fresh damage consistent with hitting a curb. Standardized field sobriety tests were conducted, where the officer observed 6 out of 6 clues on the HGN, 3 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. An inventory search revealed 3 open and empty beer cans in the back seat floorboard and other unopened alcoholic beverages. The defendant considered to breath and blew .143 and
Quick legal note. Blowing a 143 is almost twice the legal limit in Texas. But remember, defense can still argue about how the stop was made. Was there probable cause? That's the million-dollar question here.
.145.
What did you say the stop was for?
The stop was for, there was a 911 call that stated there was a vehicle driving the wrong way and described the vehicle. The officer found the vehicle.
Driving the wrong way?
I'm not sure. Well, the officer found the vehicle was not driving the wrong way, but it matched the description given by the 911.
Right. Anyone can call and say anything. Did he view any kind of traffic infraction? I could literally call and say, hey man, the state's driving nuts. Go get him. Right? I mean,
There's
Yeah.
no other
Okay.
traffic infraction.
Ms. Benson, I'm going to find that there's no probable cause to go forward with your case. There's enough death and destruction on our streets. Now, play it safe. The last thing you need is to end up in a 6x9 because if you get into an accident, maim, kill someone, especially with alcohol in the car. Do you understand? Play it safe. Don't make any boneheaded moves. Please.
Thank you, Your Honor.
All right, you are Kara Lopez.
Yes.
Ms. Lopez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 26, 2025, the officer was dispatched to a crash on Antoine Drive, Orange County, Texas. The officer learned that an unknown party called 911 at the time of the crash. It was informed by another officer who arrived on scene that the defendant being treated by ambulance. The officer informed the other officer that the defendant had already been transported to receive medical care. After spoke with the real witness, who stated that the defendant
Hosh chugs a bottle of vodka right after a crash? Okay, question for you. Is that panic bad judgment or a sneaky trick to throw off the timing of a blood test? Drop your theories in the comments. You need to hear this one.
Whoa, did you catch that? The witness says Carol grabbed a full bottle of vodka and chugged it like water, right after a crash. Now, let's pause. Is that desperation? Panic? Or an attempt to manipulate blood alcohol timing for the test? Let me know in the comments. Why do you think someone would down vodka post-accident, in front of a witness?
The assault occupant and struck the witness's vehicle, causing damage. The witness stated they observed the strong odor of alcoholic beverage meeting from the defendant and the witness in contact with him. The witness stated that the defendant was still in the driver's seat at the time of their interaction and that it was clear the defendant was intoxicated. The witness reported that the defendant had slurred speech, was incoherent, and not making sense. The police stated to the witness, "I don't know where I am." The witness reported the defendant called, the defendant cell phone crashed, and immediately after that call, the defendant grabbed a bottle of vodka and consumed the entire thing in front of the witness.
What?
Yes, Sherman. That's what happened.
She took a bottle of vodka and consumed an entire bottle of vodka in front of the will witness?
That's what I have here, man. The will witness noted that the defendant drank the alcohol bottle as if the defendant was drinking water.
Just when you think court transcripts can't get crazier, they do an entire bottle of vodka down like water in front of witnesses. I'm Imagine being that officer writing the report. How do you even type that with a straight face?
Just when you think you've heard it all, man. I mean, really.
The officer observed an empty bottle of toxic vodka, and then went to the hospital to make contact with the defendant. The officer observed the strong odor of alcohol beverage from the defendant, observed that he had slurred speech and glossy eye. The officer read the DIC form for the defendant when the defendant became coherent, and it proceeded to a breath test and blood test. The hospital discharged the defendant, and the defendant was transported to the Joint Processing Center, but was unable to perform the state arrest for sobriety test due to the defendant's failure to follow instructions and to keep the defendant's and the inability of the defendant to keep her head up. The officer took the defendant's failure to follow instructions as a refusal. The officer was unable to get the defendant to stand upright to perform HGN, and due to the physical condition, the officer did not ask the defendant to perform walking turn or to walk stand. The officer concluded the officer offered the opportunity to provide breath and blood. The defendant declined to provide breath or blood, and the officer proceeded with a residual search warrant for the defendant's blood. The officer was advised. The officer was advised the blood would be ready in 2 to 3 days. The officer noted that. That's all I have.
Do you have blood back? Or no?
I do not. I'm not sure if that in the is referring to. The warrant was presented to the hospital, Your Honor, and a nurse advised that the blood is ready for 2 to 3 days. The officer.
Do you have any pride to you guys?
There was one in Caldwell County that was dismissed, Your Honor.
License?
License is. Your Honor?
This is the judge?
It's not on docket. I have to give you a case number. You ready?
Yeah.
255-7402.
Thank you.
If you speak English, right?
Yes.
If you have a problem with alcohol or drugs, now is the time for you to address it.
Notice what the judge is doing here. Tough love with a twist, he's laying down one last warning before hammering her with restrictions. Do you think judges should use this no-nonsense fiery approacher? Would a calmer tone work better?
Because stop.
I don't care who you are, even if you're a small farm animal. Judge Fleischer is not here to play. That line was more than just drama. It was a legal warning masked in fiery courtroom rhetoric. Judges often give one strong warning like this before locking down conditions. Do you think this tough love style works better than leniency?
There's nothing that you can say at this moment. I'm warning you now, because this is the only one that you're going to get. I will do everything in my power to protect my city at all costs. I don't care who you are, what color you are, if you're a small farm animal. If I find that you're using it's not gonna go well. Do you understand?
Yes, sir.
Now is the time for you to try to get any help if you need help, because I don't know you. I've never met you before. All I know is what they're telling me. And if that's in fact true, now is the time for you to address it. I am going to put a monitor on your ankle so I know that you're not consuming alcohol at any time. I will not entertain any excuses like it's mouthwash, it's a tequila lollipop, hair dye. I've heard it all, and excuses mean nothing to me. If you consume, it's not going to go well. Because of I don't want you in the car driving. You're not allowed to drive. Do you understand?
Yes, sir.
If I find that you do, it's really not going to go well for you. I am putting now a restriction on your license that you are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught, and I'm sending this notice to DPS, so everybody, every officer in this state knows, if they pull you over and they don't see an interlock, they will take you to jail. Do you understand? And then you and I will have problems. Just don't.
Judge, this is Carla Lopez first,
Yes, ma'am.
and then you said no driving?
Correct.
Thank you.
And then a scran, please.
Yes, Judge.
You have the ability to hire a lawyer, ma'am. We will give you an application. You missed court once. A warrant is now in effect for you because you missed court the first time. I will reinstate your bond now, but this is the only get out of jail free card that you get. If you miss court again, you violate any of these conditions, you will stay with me. And I don't know who you have in this life, but if you don't have anyone to pony up $5,000 to $10,000, you will be stuck like Chuck until this case is over.
And there it is been reinstated, but with strings attached, one slip, one missed court date, and it's game over. Now here's the bigger question. Do strict bail conditions really keep people in linear or just set them up to fail? Let's discuss.
Do you understand? All right, come up. We'll have you sign this. I need you to fill an application. Deputy Miranda's going to give you an application, and we'll go from there.